Record and share. Okay, can you see my screen?
Yes, I can see it now.
Okay, perfect. All right. Well, I appreciate again for being on the call. Thank you very much. I know we had to push it today from our standard time of 2 p.m. We have Bold going on every Tuesday for the next 6 weeks. So we either are going to push it for 4 o'clock moving forward until we complete and graduate Bold. So
Got it.
we may not have a lot of people part of this, but that's perfectly fine. It's going to be recorded, which is a plus. You can always go back and listen to the video itself. All right, James. So what we're going to talk about today is the Realtor Professional Standard Process. And the reason I'm bringing this up to your attention is because we're getting a lot of confusion when it comes to the initial process of an arbitration mediation and what is a complaint coming in as, you know, agents to agents or the consumer complaining regarding a real estate agent or a real estate company in itself. So today's topic is going to, you know, talk to you on the avenues of what professional standard and what the process is. So without further ado, let's continue.
Great.
All right, so what is the professional standard? A Realtor Local Association professional standard program consists of two separate processes. One is arbitrations and then disciplinary complaints, okay? And we're gonna dive deep into the pros and cons regarding arbitration and what it entails. And then, you know, the disciplinary complaints, once they find you in violation of a standard, violation or an ethics complaint itself. So arbitration and disciplinary complaints. Arbitrations are considered monetary disputes where the person filing the complaint believes they're entitled to money from a member as a matter of law. One of the process that I've been involved in an arbitration case is like procuring costs, right? Procuring costs. You're hosting an open house, a consumer walks into your open house, you have a registry as an example, right? The consumer signs it up and you may have a couple of questionnaires on there that says, are you working with a realtor? Have you been pre-approved? So on and so forth. And then the consumer doesn't put that they are working with a realtor, but in essence, they really are. You're hosting, you're giving information about the property. Now they want to work with you. And then you get a call from a agent or a real estate brokerage saying, hey, you know, that client that you submitted an offer, that was my client. We're entitled to commission. We're going to go after, and we're going to go through the initial arbitration process. Right. And basically it's no difference than a court hearing. You know, there's someone that's appointed as the arbitrator. They listen to both sides of the story. You have what's called a opening statement, cross-examination, and your final, you know, statement. And both parties get to, you know, plead their position. So right. It's a great process. It can be a little overwhelming if you're not prepared, but it's obviously the evidence. Who holds the most evidence in this case? Right. Within 24 to 48 hours from that time, that's when they'll give a decision, and then that's it. Either you are or not, and it's also monetary as well, such as commissions. Disciplinary complaints allege that a realtor, a member, has violated one of the rules of the local association or the National Association of Realtors Code of Ethics and or the MLS professional standards. So again, those are some of the parameters of the arbitration is monetary disputes, whereas disciplinary complaints are complaints from the National Association of Realtors Code of Ethics, right? And those standards that we have to uphold on our business on a regular basis. Right. Okay. So who can file a disciplinary complaint? So any person, member or non-member can file a complaint. A board of directors may direct the grievance committee to investigate a file on a complaint. A grievance committee may investigate on its own motion and file a complaint. A board of directors as a group should not be the complaint. So anyone can file a complaint. You know, if you've been doing this for a long time, you're going to get a complaint, and it may be some of the most ridiculous complaints that come in. You know, hey, I've been trying to reach out to the listing agent and I have not heard. It's been 3 days, 4 days, and no response back. We submitted an offer, we haven't got any answer back, right? That's a complaint. What do? They call the office. They want to speak with the broker. They want to speak with the team leader, and they want to get an answer, because again, part of the professionalism of your position, right, is to make sure that any and all offers that are coming on your listing, right, are being serviced, and more so given to the seller to make a decision of which direction to go with. But people will, you know, complain. Agents as well, and consumers, right? Consumers are, you know, I've had, you know, someone list my property as an example, and 30 days in, they're unsatisfied with the listing agent's results, and now they want to cancel, right? Now, a seller cannot just unilaterally just to cancel if they're not pleased with the overall service. There has to be a reason behind that, okay? And that reason has to be in writing, and that has to be brought to my attention as a broker or a team leader, as an example. And then I would have a conversation with the listing agent, get both sides of the stories, because there's always two sides to the story. There's the seller's side, and there's also the listing agent side as well, right? And you have to weigh it out to make a determination. And a lot of agents put a lot of time, effort, and energy into their listing servicing and getting it prepped, right? And doing all that is necessary to get it ready for the market. And sometimes the consumer just is not happy with the process, or lack of communication, or no updates on what's going on the regular basis, may put a damper in the sellers and may want to cancel. So there's many variables that can happen that alter the seller from, you know, wanting to cancel. So they can, again, file, complain, and also reach out as well as part of the process. Form of discipline. So the number one, attendance. If you are in a position that they find you that you violated an ethics or in violation, then here are some of the aspects of what could happen if you are disciplined in this manner. Attendance of course and seminars designed to increase realtors' understanding of their ethical duties and responsibilities. Number two can be a letter of warning or reprimand placed in the violator's file, okay? That can happen too, is that they'll keep track of you, and if they see consistent letters of warnings, they can ultimately, you know, sanction you, remove you, and terminate your membership as well. So you got to be very careful, because too many of these warnings will lead to an escalation and maybe a potential of termination of membership as well. And also number three is an appropriate fine not exceeding 15,000 or. Number four, association or MLS membership suspension, termination, as I stated earlier. So these are the four things that could happen. Is the remediation, saying, okay, you know, it's more of a slap in the hand. We're going to discipline you, but with that, you also have to take some ethics classes. No difference than, you know, have you ever gotten a traffic citation, right? And you have to go to traffic school, and some of the principles in traffic school is learning the laws of the roads, right? And it's an 8-hour course. Sometimes it's breaking down into two parts, a 4-hour session, and then the following day, part two of it, or it can be a full day as well. That's one of the things that could happen if you are found guilty of a violation or on ethics complaint as well, that they find you guilty. Then obviously number two again is the warning letters, right? They'll give you a warning, hey, you've been advised that someone has, and we found that you were in violation of it. This is your last warning, or you'll have additional warnings that will ultimately be put into your file. And then obviously 3 and 4 is monetary fees as well. And that can go also with the MLS. How many times, if you're listing a lot of properties, if you fail to follow the rules and regulations of the multiple listing service, then what happens is that they may fine you. And I've seen fines in the excess of $200 to $300 and sometimes $500. And if you don't take care of that, what happens is it escalates, and then they'll suspend your MLS as well. And now you cannot utilize the MLS for the benefits of helping your clients. And then ultimately the last, and this is probably where it gets to be at the peak of a disciplinary situation, and that can be 2 parts, where they're also fining you and suspending your membership with the with the MLS as well. So be very careful. And obviously, if you feel that there's some type of red flag, something doesn't feel well, then always bring it up to your broker, your team leader, and get some guidance and support for that as well.
Right.
All right, so who is responsible for enforcing? Well, the grievance committee is one, preliminary review ethics complaint. So there's a grievance board of advisors that every month they meet at all the local board memberships, or the local board, such as, like, for example, South Bay Association of Realtors, the Los Angeles Association of Realtors, Pacific West Association of Realtors, Palos Verdes, or whatever association. There's a committee that get together once a month and go over these preliminary ethics complaints that come in, and then they categorize them in of importance and priority. And then they meet is, what is the next step that we must do in order for us to determine if the individual agent is in violation or has broken one of the ethics in violation of their position or their practice. Next is the Professional Standard Committee. Members serve as a panelist for disciplinary hearings and arbitrations. So these are individuals that will listen to the case and will ultimately get together to listen to either side. If it's one person or if it's multiple persons, the Professional Standard Committee is a panelist who are there to help navigate the initial process of either the complaint or the violation of the MLS, the National Association of Realtors Ethics, Code of Ethics as well. And the Professional Standard Committee will then come to a conclusion and finalize if there is something that needs to be escalated or fined or reprimanded. The board of directors act as a appealing body for the Association Professional Standards Program. So with the grievance committee, the standard committee, the Professional Standard Committee, and the board of directors, this is where the responsibility enforcing the rules and regulations, folks, of our position as professional real estate and members of realtors as well. General procedures on the arbitration. An arbitration hearing is scheduled if a mediation does not result in a settlement or if the parties refuse to mediate. So if you understand the initial process, and this is again part of the purchase agreement, right? There is mediation, arbitration, and what we call liquidated damages provision on the purchase agreement that allows the consumer and more so the agents to dispute if one or the other is in violation of any of the codes of ethics or any of the MLS, or just, not practicing professionalism in your process, right? And there's a lot of times where agents would just want to file complaints because they're just unhappy with the turnaround. And it's the funniest things that we get. Well, they didn't call me. Well, when did you call? When did you leave a text? When did you email? Well, I left an email about an hour ago and I haven't heard anything. And people will complain about that. Again, utilizing common sense is very, very important, because everything is all about paper trail, right? Paper trail. Number two, at the hearing, both parties can present documentary evidence of witness testimonials or to the hearing panel. Number three, the panel will then decide whether to award money to the complaint. And four, the losing party to the arbitration can request a review of the decision before the panel of the board of directors, but only for alleged procedure deficiencies, okay? And that's, again, it's a little different than your standard practice of going to small claims, right? When you go to small claims, superior court, you're in front of a judge, you plead your side of the story, the plaintiff, and the opposing side will plead their side of the story, and it's up to the judge to come to a conclusion and who is awarded any monetary damages regarding whatever the complaint is. Well, the arbitration works a little different, but also works somewhat similar to the jurisdiction of the superior court, is that you are appointed an arbitrator that will listen to the case. As I said earlier, you do the opening statement, the cross-examination, meaning that you can ask questions to the opposing party, how they came to be, the complainant, or how they became the person that got awarded a commission. An example, and you're fighting for a procuring cost claim. So it can be many variables on this. And then number four, the losing party to the arbitration can request, again, if there is some deficiency and there was something that they did not really see that it was part of the process, then yes, they can request, and this is only if you are the losing party, right? Request to have a review of this decision and escalate it as well.
Right.
All right, enforcing of an arbitration awards. If a non-prevailing party fails to timely pay, prevailing party can request a show cause hearing before the board of directors. The non-paying party has chance to explain why they were unable to pay the award. The directors can suspend members or mandate a payment plan. Okay, any additional parties have the right to petition a court to have an arbitration award confirmed. Now, let me just explain all this. This is again based on an arbitration. So let's say that you are fighting for a procuring cause. In this procuring cause, you end up winning, that your compelling evidence, supersedes the opposing party, and now the arbitration process awards you, say, $15,000.
Right.
And now the other party, and that can be the consumer or the real estate company or the real estate agent in itself, they can request again if they have not paid, because they have a certain period to ultimately pay you what was the awarded amount.
Right.
So typically they allow anywhere from 6 to a year, depending on the size and the amount that you have been awarded. So here's the initial process. If they are not complying with the arbitration award, is again, you got to show the reason, show cause of the hearing in front of the board of directors, and then the board of directors will listen to your case. It's been 7 months. I have not received 1 cent from the award back in January of 2022. And then obviously explaining, from the time of the award into the time of the arbitration award in front of the board of directors to determine, the reasoning that the opposing party has not paid you. And then that will ultimately give the opposing party who has been brought into the arbitration and has lost the case to come up and say, well, tell us the reason you have not paid Keller Williams, or the reason you haven't paid, the agent itself. They're going to explain, well, I don't have the money and all this stuff. So they'll say, well, we can always put a payment plan that's an agreement between both parties. And if that agreement is satisfying, then, it's those monthly payments until that balance is paid off. If they don't have a very good compelling position, then what happens is then the directors can suspend a member with the local board, and that includes, terminating or, not terminating, but suspending your multiple listing service, your MLS, and also your zip forms to allow you access until you take care of this award.
Exactly.
Okay.
So
Yes.
I'm sorry, just one question. At the end of the arbitration, if you're the losing party, would they ask you, or would they say if you're able to pay, or how would you like to pay payments, or can you do a lump sum? They don't ask you that question, just give you a time to pay it. And if you don't pay it, then you would go to arbitration again, ask for that, why he didn't pay me. Is that correct?
Yeah, to a certain extent, that is correct. So before it finalizes, you can definitely bring it up to the arbitration hearing and say, if we are the winning party, then, we would like a full sum paid in full. Because at the end, when the decision is made, then it's between the parties to come back to an agreement. It's not up to the arbitration to say, okay, well, you got to pay, the 15,000 in the next 6 months. They'll let the consumers, the parties involved, determine if the party that is the awarding party that wins the case, they may say, look, I don't want any payment. I just want the 15,000. You can pay me direct, wire, cashier's check, whatever the case may be. Then that's where it ultimately, because the awarding party will also have to file a form that says that the opposing party has satisfied this case and has paid in full, and then that gets sent. And if they don't, the grievance committee on a regular basis will say, is this still an active, pending, or closed case? And then they'll check in with the parties to find out, has the consumer or that real estate agent or company taken care of their outstanding balance and amounts. And if not, then they'll reach out to the opposing party and find out what the status is. But you, as a real estate agent, you have to be the one proactive in it and engage in making sure that you're being responsive and responsible on getting the money that you won in the case.
A final question: is that the same with mediation as well, and arbitration in terms of
that is correct? Yes, sir.
Okay,
Yeah,
great.
it's both arbitration and mediation. Now, mediation is a little different because mediation is spontaneously right after either you agree or you disagree, right? And a mediation is basically how it works is a mediator will have two parties in two separate rooms. And the mediator will go to one room and says, look, I know that the buyer's deposit is $20,000, and I know that the buyer has released any and all contingencies, and we know that the buyer has canceled, but the buyer is not going to sign off and release the $20,000 to the seller. Can we come to some kind of compromise and resolution that I can present to the listing agent and the seller? Okay, so the buyer will say, look, I'm willing to give half of that $20,000 and I'm willing to release $10,000. And the buyer may say, there was a lack of response time, lack of disclosures, whatever the case may be from the seller. And this is why the buyer feels compelled that they do not want to release the entire deposit, which again, the contract is the contract, and it already says that, the buyer, after releasing all contingencies, may forfeit their entire deposit in escrow up to 3%, right? And the
Right.
seller may come back and say, look, no, I want the entire $20,000 that is in escrow, just because the buyer has dragged their fees for more than 30 days. I already lost the opportunity. I did all the repairs, and the $20,000 that's in escrow under exceeds my cost in selling this property. One, because I could have sold it for more if the buyer had not submitted the offer. We could have sold it to another party that was going to offer us, but I was so compelled with the buyer and the family wanting to buy this property, we decided to go in that direction. So again, there's many variables, many scenarios that can happen. So the mediation process is, again, it's just like playing tennis, back and forth, until both come into an agreement. So if the buyer says, I'll give 10,000, and then the seller says, look, I'm fine, okay, I won't do 20,000, but I agree to release this escrow if this buyer is willing to at least release 15,000, right? So
Right.
then the mediation will go to the buyer, says, look, we got some great news. The seller says, look, we can get this resolved as long as the seller gets some compensation. He's willing to do 15,000 instead of the 20,000. That means that $5,000 will be released to you, and 15,000 will be released to the seller. Buyer comes back and says, no, $15,000 is a lot of money. I'm sticking to my guns. I'm sticking to $10,000, and that's the most that I'll give the seller. Because yeah, I did breach the contract. Yeah, I did release all contingency, and I want to again abide by certain things that I saw that I did wrong in forfeiting my position. But $20,000 is just a lot of money that I'm just not comfortable releasing. So please, go back to the seller and says, we have no deal. If they are not willing to take $10,000, then we walk. So the mediation will go into the seller, and the listing agent says, look, the buyer's staying stern in their position. They're willing to go ahead and cancel so we can all move, but they're only willing to do 10,000. Okay. Then
Right.
the seller says, okay, look, I just don't want to go back and forth. Let's meet in the middle from 15,000 and 10,000. If they can meet us at 12.5, we have an agreement. We can cancel. We can all move on. I'm good. Let's present it to the buyer. So the mediation will go now to the buyer, says, look, okay, the seller is willing to go ahead and release, this cancellation of escrow and, give you back more than what originally they're entitled to. So the seller says, if we can make this work, they will accept 12,500 as an example, right? And I'm just throwing a number. Buyer says,
Exactly.
look, no, I don't want to do 12, but I'll do 11,000. Okay, so then the mediation person will go back to the seller, says, I have great news. They did not agree to 12.5, but they're willing to do 11,000. I say this is the final. If we cannot come to an agreement, then this is just a whole hour, 2 hours, 3 hours of waste of time. I suggest, again, this is you, take the 11 and run. All right, you convinced me. Let's just go ahead and do 11,000. So the mediation will draft a summons of the request and agreement. Both parties sign. That is now given to escrow. Escrow will now cut 2 checks, one for the buyer, one for the seller, and obviously the seller will get 11,000, and the buyer will get 9,000 back from the actual deposit. That's what a mediation typically is. It's just back and forth, back and forth. And arbitration works a little different. It's more like you're in front of a judge, you're pleading your case, and then you don't get a decision immediately. It takes 20 to 48 hours before the arbitration, and they will not call you. They will send you an email and then a certified letter of the finalization of what the arbitration and the evidence brought upon to determine who is the winning party. That's typically how it works. I hope that kind of answers your question.
It did very much so. Because of all that, I have 3 questions that comes to my mind because of all your explanation.
Yeah.
One thing is that, first of all, do you have to pay for mediation because their time is valuable? Do you have to pay for? I think you have to pay for that. There's a cost to that, right?
That is correct, yes.
And who pays
With
that?
a mediation, there is a cost. With an arbitration, there is a cost as well.
Who pays that? The losing party?
Well, no. So whoever wants to file the mediation typically is 50-50. Whoever brings it up and wants to have a mediation will start the initial. And then now that forces the opposing party that they have to be dragged into a mediation to pay. And it varies from different local boards. I've seen it from $500 to $800 for mediation. And then there's also the cost for the mediator too, their time listening to both sides of the story, and then ultimately finalizing the summary that both parties come to an agreement. And then they usually charge anywhere from $100 to $300 per hour. So the
Wow.
faster you can resolve it, the faster you can eliminate a lot of the
Keep the
costs.
cost.
Now,
I imagine.
when it comes to the,
Yes,
sir.
I'm sorry. I imagine if it's going to be longer time, they're going to charge you more money.
That is correct, yeah. So they usually want 4 hours in advance. So they'll say, we'll do 4 hours, and whatever we can get it into an agreement in those 4 hours is usually already paid for. Anything over 4 hours, they'll stop and say, look, our 4 hours is up. If you want to continue this, we can reschedule. That'll be another maybe hour, 2 hours that we'll charge. And then that's when they'll bill you for that amount. And again, on a mediation, both parties, the buyer and the seller, or even the agents involved in this, will be the ones incurring that cost.
Gotcha.
Okay.
And you can't bring any outside counsel, both to mediation or arbitration. You cannot bring any lawyer or someone with legal advice to represent you in those cases. You have to represent yourself. Is that correct?
That is incorrect. So on a mediation, yes, you can bring counsel. On an arbitration, no, you cannot bring counsel. You have to represent yourself as per, or have your clients with you. They can get advice from an attorney, but the attorney cannot be part of the process in an arbitration. And the mediation, the answer is yes. You can have an attorney there with you, guiding you, negotiating on your behalf with the opposing party, but that's the only time. On the arbitration, it works a little different. Now, it really depends on what the scenario is. Now, if it's a disciplinary hearing or an ethics issue, I still believe that in arbitration, you cannot bring a counsel, but you can be advised by counsel and speak with the counsel prior to your hearing, and be guided by the attorney that you have chosen to kind of prepare you, and then articulate your position to defend yourself from a disciplinary action. Because if you do get a disciplinary action, there's a process, especially by the National Association and the California Association of Realtor. They literally take a photo of you like a mugshot, and then it's posted with the violation that you were involved. I don't know if you've ever been to the California Association of Realtors, but there's a section in the site that allows you to look at all these violators, and these violators that have broken certain ethics and NAR or CAR violations, or even the MLS, doing unpractical situations or taking shortcuts, violating any of the rules and regulations of the policies and procedures. And if they find you guilty as well, then yeah, they'll have a photo of you and an explanation of what transpired and what a violation. So you do not want to be you don't want to be put on this list, because this is somewhat like a blacklist. And any real estate agent has full access to this information. And if it's a local agent that you are aware, they can use that against you. And meaning, if you're going on a listing appointment and you're against other agents and they know that you're on this blacklist violator, they can say, well, who else are you interviewing, right? Well, I'm interviewing, Simon over at Keller Williams. Simon Cazares? Yeah, Simon Cazares. Quite interesting. Were you aware that he was involved in a violation? And then they can pull this information. They're going to see my face, and yeah, that's Simon. That's the guy that we have a listing appointment, and that may put a bad taste. Again, bad taste in the consumer or the seller's mouth. So you got to be very careful. This is why I always say, always do the right thing, work out of integrity, never take shortcuts, and follow the rules and regulations. And that's how you'll survive, a long career in real estate.
Well, thank you. That was a good explanation.
Yes, sir. Thank you. All right,
Thanks,
number
Simon.
4,
That
the
was a
losing
good
party can
explanation.
Huh?
That was a good explanation. The
Thank you.
arbitration. Yeah.
Yes, thank you. Thank you. I appreciate it. All right, so the losing party can request a review of decision before the panel of board of directors. All right, so let's continue. Disciplinary options. Associations can discipline realtors for violating the code of ethics, the MLS rules, and or membership duties. Duties include in the association bylaws. Associations can require realtors to pay money to parties filing ethics complaints, cannot award punitive damage for violations of the code of ethics, and cannot suspend or revoke a real estate professional license. The primary emphasis of discipline for ethics lapse is educational to create a high awareness of any appreciation for the duties of membership. At the same time, more severe forms of discipline, including fines, suspensions, termination of membership, may be imposed for serious or repeated violators or in violations. Okay, so don't be that agent that you're constantly getting yourself into these traps, right? Because it's very easy to do so. Practice good habits, do the right things, do not take shortcuts. And if you have questions on the do's and don'ts, bring it to your broker, bring it to your team leader's attention, and let them be your eyes and ears to help you navigate that. Because again, at the end of the day, our number one goal is to help you succeed, and more so, help you grow in your business as well. And the last thing we want is to take time, effort, and energy, because now we have to be dragged in a mediation, dragged in an arbitration, dragged to court, because we could have easily prevented it, we could have been proactive, and we decided to go solo on this, and now you just fell in a trap. And that can be overwhelming, can be very stressful, and sometimes anxiety kicks in because you just do not know what the outcome is going to be if you're found guilty of any of these rules and regulations. And then more so, the fines that are involved, and that's not fun either.
Yes.
All right, team. So there's an additional resource, quick guide. All this information is straight from the California Association of Realtors, professional standard materials, right from the CAR's website, webinars as well. And the cool thing is, like, if you just click here as an example, let me see if it comes up. Here we are. So here are the standard materials that you can get from the NAR Professional Standard Enforcement, COVID-19 and the codes, and then checklist, folks, right here. Again, this is all part of the California Association of Realtors. Mediation 2022, arbitration procedures and reviews. You can get them on PDF and Word. Show cause hearings, disciplinary complaints without ethics advocate, discipline complaints with ethics advocate, discipline reviews, citations, reconsideration, cooperative enforcement agreements, manuals and guidelines of the California Code of Ethics and Arbitration manuals that you can download and review. These have been revised this year. And then there's red revisions on there for everything that was revised this year. So again, all this stuff is the most updated information that the California Association of Realtors has for us. Arbitration implementation guides. And why is this very important? Because if you're proactive and you're engaged, you know the procedures, then it'll give you an upper advantage if you're ever dragged into an arbitration or a mediation or even a court hearing. It gives you knowledge, right? Knowledge is power. One of the recommendations that I really encourage you is the procuring cost guideline, the do's and don'ts. When I went on a procuring cost claim, not me personally, but one of my agents was dragged into an arbitration regarding procuring costs. I ended up downloading this and I studied this for about a week, and I was mentally prepared to help, because at the very end, when we had the date, the agent was just so nervous. And she says, I don't know if I can do this by myself. I says, don't worry, you know, as the broker, as the team leader, you know, I will be there. But I ended up stepping in and really handling the entire process for her. And we ended up winning the case, and we did not have to pay the opposing brokerage and agent commission from the commission that she earned during the process. Finding of facts, drafting guide. Again, these are all resources for you straight from the California Association under professional standard materials, folks. Again, all this cool stuff that you have easily accessible to you. Now, here's the National Association of Realtors Code of Ethics, case interpretations, arbitration guidelines, and other stuff that you can take as well. Now, I think let's see if I can populate this. I think it's here. So here it is, Code of Ethics. This is what I was saying earlier, that, you know, these are real estate agents that are found in violation, okay? You have access to this information through the California Association of Realtors. Here's the most updated one, which was on April of 2022. Again, this is public information just for members of the California Association of Realtors. What's so ironic, it's like a mugshot. They take a photo of you, they put in your name, they'll tell you what city you're at and what they found as in violation. So this individual was in violation of Article 16 of the Code of Ethics. As a result of this violation, a letter is filed for 3 years, and there was a fine of $6,000, folks, $6,000. Now, then it goes into details of what transpired. You know, was a broker associate for a real estate firm, but then left for a new brokerage while he was a broker associate for the first office, and an exclusive buyer broker agreement with the client, left the firm during the term of the agreement, and then he wrote a purchase. I can't, for some reason, it's not shrinking here. Behalf of the same buyer with his new broker is violating the terms of the exclusive buyer broker agreement. So again, you know, it has access to all of these violators as part of it. I encourage you, because it's an eye opener for all of us, that the most simplistic things that you think are not so big can cause potential ethics complaint and violations of the bylaws and policies and procedures. So be very, very careful, because again, you don't want to be on this list, because any agent can use this. Oh, by the way, that person that you have a listing appointment with, he was in violation of Article 16 of the Code of Ethics, and that cannot put a good taste on the sellers because, we work with high integrity, right? And always doing the right thing. So things happen, there's probably a lot that involve this in its initial process. But again, the pros and cons and understanding of an arbitration case, and then ultimately a ethics complaint can be side to side as well. So just kind of giving you a large perspective in how this all can play out. All right. Any questions regarding this? All right.
Nope.
Well, I hope this information was informative. Again, all this stuff that I do gather mostly is through the California Association of Realtors, which provide us with the zip forms, the contracts, and that's what keeps us all together regarding the do's and don'ts, right? And ultimately, let the contracts do justice. Don't take the shortcuts. Don't create other verbiage on there that can now be confusing or can alter this and now put us in a liability. So just food for thought on that. All right. Well, that's pretty much all I have. I hope this again was of some understanding, but more so is, be careful out there, do the right thing, ask questions. And if you don't know the answer, don't guess, just say, look, I don't know the answer, but I have the resources. Give me, 24 hours or give me some time and I will get that information. And then, we have the legal department. We also have the broker and the team leaders to help. And then you have other resources too, your fellow coworkers as well, right? Other real estate agents, maybe they've been through that scenario and they might be able to give you some guidance and support as well. So with that being said, that concludes the class. I appreciate you all. Thank you very much for hanging out with me. And again, if you have any questions, you can always reach out to me via email, phone call, or even a text. All right. Thank you very much.
Thank you, Simon.
And
Very
Thank you,
informative.
Simon.
thank you. Have a wonderful afternoon.
You too.
too.
Bye-bye.
Bye-bye.